Hi, welcome to your fourth module of your IP course. This module is titled The Economics of Intellectual Property, Innovation and Creativity, and we'll be looking at the policy linkages between IP and innovation and creativity. I'll be mentioning which slide we're on as we're going through the lecture so that you can follow on the PPT as I discuss. The last 200 years have seen intellectual property take on a very significant role in how innovation across the world is gone about. Of course, intellectual property is not the only way in which innovation can happen, but it has taken on a central role in especially the last 200 years or so. With the knowledge economy growing, the importance of rights over information, rights over who has information, what they can do with it, this plays an increasingly important role in how economic development and economic growth happens. It plays a significant role in how culture is spread. So, in some way or the other, intellectual property is almost always interfacing with our day to day lives and our day to day activities. When the first wave of scholars initially started studying intellectual property, they focused on it as drivers of economic activity rather than as mechanisms through which innovation can work. So, in a way, they focused on it as an end in itself. However, this gave way to the second wave of scholarship in intellectual property, and the second wave placed intellectual property in a wider economic context, in a wider social context, looking at it as one of several different activities that promote economic growth, that promote cultural growth, that promote technological growth. And by placing it in this larger context, they focused on how intellectual property interacts with all these different other activities which also affect and contribute to these various types of growth. In this module, we'll be looking at this economic analysis in this second wave of scholarship. Since we're looking at this from a policy perspective, we'll be focusing primarily on the normative analysis. That is, rather than focusing on what is right now, we'll be looking at what ought to be, the prescription of desirable consequences. Let's move on to the third slide, that is the economic analysis, part 2 in the readings. Now, there are four major schools of thought on IP. They are the natural rights or the Lockean theory, second, the personhood or the Kantian theory, third, the social welfare or the democratic theory, and finally, the utilitarian theory. Very briefly, though you probably will be studying or have studied this in other modules, the natural rights theory looks at rights as something a creator deserves. That is, if they contribute to something, they deserve to get something back from it, and hence they get intellectual property rights over such contribution. The person-here theory then looks at intellectual property as crucial to the satisfaction of fundamental human needs. That is, IP could be justified either by saying that expressed their will, that is, their personhood, through a certain type of activity, and hence, in order to protect that expression from appropriation or modification, they need intellectual property rights over such creation of theirs. This is one way that the personhood theory looks at it. The other way is that the contribution to society creates social and economic conditions which are conducive to creating intellectual activity, which is in turn important to human flourishing. Thus, this is the second way of justifying intellectual property. Then we have the utilitarian method. The utilitarian method is the most accepted or the most widely accepted version of the justification of IP. And the utilitarian method, very simply put, says that intellectual property rights should be shaped so as to maximize the net social welfare. We'll be discussing the utilitarian method in a little more detail a little later. And finally, we have the social welfare theory, which is very similar to the utilitarian theory, except it is willing to take a moral position. That is, it says that rather than just the maximum benefit for the maximum number of people, it specifies what a just and attractive culture is, which does not necessarily mean the maximum benefit for the maximum number of people. For a more detailed analysis on these theories, I would highly recommend reading William Fisher's Theories of Intellectual Property. I've referenced the citation in footnote 7 if you want to look it up. Now, the economic analysis of IP primarily concerns itself with the utilitarian justification. So, as I said before, the utilitarian theory justifies IP as mechanisms that can be used to maximize social utility or social welfare. Now, this is easy to understand as a broad principle. You want the maximum benefit for the maximum number of people. But translating this question into administratable terms is a little more complicated, since the utilitarian theory doesn't describe which people you want to benefit, or what does greatest good mean, or why should you look at a majoritarian outlook on welfare. So translating this into administratable terms requires us to answer two questions. First, how do we achieve greatest good for greatest number, that is the utilitarian ideal? In other words, how do we achieve maximum social welfare? And the second question is, when we figure out how to achieve this, how do we apply it specifically to intellectual property law? Now, for the first question, that is, how do we achieve maximum social welfare? The broad law and economics movement has given us two broad methods which can be used. Firstly is the Kaldur-Hicks criterion. This is a measure of economic efficiency which focuses on maximizing welfare by preferring outcomes where the party gaining from the shift from one scenario, that is the benefiting party, could either practically or even just theoretically compensate the party being made worse off, and even after such compensation still be better off. Since this compensation only needs to be theoretical and doesn't necessarily need to be practical, it could, therefore a more efficient outcome can in fact leave some people worse off. An example of a outcome that is approved by the Kaldur-Hicks criterion would be if factories and people around them come to agreement that the factory will continue to pollute after compensating the people. Therefore, even though it's continuing to pollute, it is making enough profits to compensate the people being harmed as well as continue polluting. This would be an outcome approved by the Kaldur-Hicks criterion. However, since under this method, the factories aren't actually required to compensate the people around them who are suffering the harms of pollution, even though they don't compensate the people, this would be considered an approved outcome under the Kaldur-Hicks criterion, just because even if they did compensate, they would still be able to continue. Now, looking at wealth maximization is a method of achieving welfare, of maximizing welfare by focusing on the use of wealth as a proxy measure for social welfare. That is, the wealth maximization system prefers outcomes which maximize welfare, and this welfare is measured by the consumer's ability and willingness to pay. So technically, wealth maximization does not fall under the utilitarian method, but is slightly different from it. However, several scholars have strongly contended that in any case, using the Kaldur-Hicks criterion as a method of maximizing social welfare, when this is converted into practice, into actual policy on the ground, this starts tending towards wealth maximization. Therefore, wealth maximization is also a policy method which can be looked into while discussing the law and economics approach. So now we have two methods through which we can achieve the maximum social welfare, that is, two policy approaches. There are, of course, other policy approaches which also can fall under the law and economics movement or the utilitarian movement, but these are the two big ones, and this is what we'll be focusing on for now. You can look up the other methods on your own separately if you wish. Now let's move to slide number 4. Now, to translate this maximum social welfare into exact or precise administratable terms has led to, again, 3 different approaches. I'll just briefly mention what they are before we discuss them in detail. Firstly, the incentive theory, which states that social welfare can be maximized by ensuring that efficiency gains made by incentivizing innovation through IP rights, or exclusionary rights as they're more technically appropriately called, are greater than the deadweight losses and other inefficiency costs incurred by allowing such restrictions in the first place. And that is, the incentive theory looks at a cost-benefit approach, saying that efficiency gains from a greater rate of innovation has to be more than the efficiency losses which are caused by preventing free access to such innovations. Secondly, we have the property rights approach, which essentially states that property rights are the best determinants of patterns of productivity which are likely to enhance consumer welfare. And the third approach looks at IP rights as one of at least 2-3 other innovation mechanisms, and questions whether, or rather which method can be best used to reduce duplicative or uncoordinated research and innovation activity. That is, it looks to reduce duplicity of research.